I'll be on top again. I'm not gonna let you take me down. It's gonna be the whole 9 yards or nothing.
Welcome to Legal Straight Talk. Thanks for joining us again. I'm Brett Harrison from the Harrison Law Group. Tonight we have a special guest, criminal defense attorney, Alan Schwartz. Thank you for coming to Legal Straight Talk, Alan.
Thank you for having me, Brett.
Today our topic, Alan likes to call it keeping your teen out of trouble. I actually like to rephrase that and say, when your teen gets into trouble, what now? This is where Alan comes in. Okay, Alan. So let's do the typical scenario that I tend to see a lot, and you've seen a lot in your time over, we'll just say it's over 20 years. Fair enough?
Call it whatever you like.
Okay. You get a call from a frantic parent. My teen is down at the principal's office. Not just my teen and the principal and the vice principal, but a couple of gentlemen and women from the police force are there. What do I do? Do I tell him to talk? He has to talk? What should we do?
Well, the first thing we do is try to stabilize the situation by having them not talk at all until we get involved. And when we get those calls, we contact the school, we let them know that the student is represented by counsel, and we make it a point to get down there as soon as we can, if it's possible to do it at that time. Usually we will get the courtesy where they'll say, we'll pick another date for you to come in, unless, of course, it's risen to the point where the police are ready to make an arrest.
Well, you know why I say that? I don't mean to interrupt you, but nowadays in the schools, there's a zero tolerance, right, be it from anti-bullying to drugs to any type of assault or anything, because people are so afraid of liability, the civil lawyers that are suing the schools and so forth because they're put on notice. So they have the zero tolerance. And a lot of times, you know, the principal will say, listen to the child or the teen, you know what, talk to me. This will all go away. Tell me the truth. Tell me what happened. You know, I think parents, there should be some type of lecture to them that, you know what, be careful with your children, because, you know, these are young children. It could have a tremendous effect on their lives now and in the future. They don't have to talk. And I think that's one of your main points.
Mm-hmm. Precisely, because there's a time to talk and there's a time not to talk. If they have the police already been contacted, then you're in a situation where you know criminal problems could ensue. Anything that's said to the school authorities could easily provide the basis for probable cause for an arrest, regardless of what the age is. Then the only question is going to be, what court is it going to get referred to? So it's always better for them to say as little as possible and nothing until they've had a chance to speak with an attorney.
Well, let me stop you there then, because what's the obligation of, let's say, the principal now, he or she? Do they have to call you first before they speak to your child, or no?
No, they don't, and that's one of the problems that we have, because more often than not, the child's brought into an office with a figure of authority, and they're taught
the principal,
the assistant principal, a school psychologist. It could have started with a visit to the nurse in the school, and usually they're going to be very candid in what they say and not think about asserting rights.
But are they acting now as an agent for the police or for whatever agency?
Well, we don't know at that point, because we don't know what the basis of their investigation is and where it's going to go from there. But in your original hypothetical, you said the police have already been called. That, to me, sets off red flags that nothing should be said.
But
except
often,
by advice of counsel.
I don't even think necessarily the principals and the vice principals know their obligation.
No, they probably don't, and we've had those situations before that, with the best of intentions, for example, in one of the local schools about 2 years ago, there was a bomb threat, and one thing led to another, and a student was talking to a social worker or a counselor in what he thought was a privileged conversation, and the professional recorded his notes and reported what he felt he had to, and the case took on a life of its own. After the fact, the police had not been contacted, but things that the social worker felt should have been confidential between him and the student became less than confidential when the principal got involved, and then the superintendent of the school district.
And don't they get out of it saying, well, the public interest was at large, there's a greater threat, so therefore I had to say something to protect the students in the school? Is that how they get around
Well,
that?
that was their theory. The countervailing theory is that if the student can't talk to the professionals in the school in an unfettered and free way, knowing that whatever he says is going to be confidential, they're not going to talk to them. So you have to balance those two different interests and determine where it's going to end up.
But now, you're taking a young child, let's say they're 13, 14, 15, 16, they get confused. If they're going to keep it in and they want to say something because they fear whatever, but then they're worried, well, if I say something, something could happen to me. And emotionally, I don't know if they understand what's at stake.
Well, there's no reason to believe that they should, because most of our adult clients don't, and that includes professionals. It's the hardened criminal who realizes that when the police ask a question, you should assert your right to have your counsel
Better to be
present.
thought guilty than known to be guilty?
Absolutely. It's no different than in a DWI when a police officer says, excuse me, sir, if you had anything to drink, and you say only 4 drinks, only because you've never been in that situation before. So it's kind of interesting that you end up with a more naive client getting themselves in more trouble than somebody who's more sophisticated as to how the system works.
Now, what's also interesting is that what your teen may say to the principal, the vice principal, the guidance counselor, may not be used against you necessarily for the criminal case. However, they have school hearings,
Correct.
which is almost as, to a child, if he's going to get kicked out of school, is in a lot of ways worse to him than getting charged with a crime, depending on what the level of crime
Many
is.
times it is, and we see this often with seniors, and especially around this time of the year with senior pranks that go awry, senior proms that go wild. We had a case a couple of years ago. We had 3 honor students from one of the best local high schools
Right.
got involved in a situation where there was a zero tolerance policy when it came to senior pranks. And it was a very minor senior prank. Nothing was damaged, but the principal said, I feel badly about it, and the question was, do they get expelled? Can they go to graduation? Can they go to the prom? All 3 have been accepted to top schools, and obviously any of these problems could have interfered with them doing so.
Because there's, again, the principals have 15, 20 years ago, principals, I think, had more of a flexibility to say, do I really have to do something? Should I say something I want to protect? Now, they don't even have that authority anymore. It's almost like a zero tolerance again.
Absolutely.
So, and this is an interesting fact that I've seen happen numerous times, which is if they get charged criminally, a lot of times they have what's known as CPS. Child Protective Services comes now and investigates the family. How are they taking care of their other children? Do we have to move this child out of the house into another area? Do we have to put him into some type of separate home for a little bit? That can be devastating. Not only that, but it's costly to the parent. You got to defend yourself.
And very easily triggered because they're going to err on the side of being cautious. So it doesn't take a lot to launch a CPS investigation, and that becomes even more problematic because the minute somebody who is the subject of a CPS investigation asserts the right to have counsel, this really gets out of control. The CPS's response is going to be, if you're going to have a lawyer, then we have to have a lawyer, and everything becomes more complicated as a result.
And it gets further complicated because now the child is appointed a legal guardian. So now you have the legal guardian, the county, the state, CPS, you and your attorney, and it's like almost not everybody can talk. You almost can't talk to your own child at that point. And it creates an issue and turmoil for a family over something that might not have been a big deal to start with, but now it's turned from a molehill into a mountain.
Well, for example, and I agree 100%, but in the instance that I was referring to with the students with the senior prank that went awry, that then launched 3 superintendent's hearings, 3 sets of criminal charges. The parents all needed lawyers to handle the superintendent's hearing as well as, the related criminal matter.
And possibly CPS.
Correct.
Now, you as an attorney know that the parents are going to have to pay for the CPS, which would normally be in family court. They're going to have to pay for that for that attorney for handling that situation. They're going to have to pay also for the superintendent's hearing, which can be, in some counties, quite honestly, in some districts, a kangaroo court. Because the person making the decision is the person that's also, the principal could be making the decision, or a school board who may not be as schooled in the law, may not be as schooled in the situation overall. And that's a scary prospect. Now, on top of that, you're going to also have to hire an attorney for the criminal matter.
Correct.
And on top of that, you're supposed to still go to work.
Mm-hmm.
And they don't do these hearings and these court appearances on Saturday and Sunday and after 6 o'clock. So does a parent just throw their hands up? I mean, what do you do?
The best thing you do is hire competent counsel, and if you can get somebody who can handle all of those things, or one firm that can handle everything, so it's done in an integrated fashion, then you avoid the need to have lawyers working at odds with each other.
Which often happens.
Because you end up with a lawyer who's handling the CPS investigation may have one set of priorities, the attorney who's handling the superintendent's hearing may have a different set of priorities, and of course the attorney handling the criminal or quasi-criminal action is going to have an entirely different set of priorities.
Then there's another problem. If you're in CPS, if you're in the family court, they don't have to appoint a lawyer for you on your behalf as the parent. You have to pay for it.
Right.
So you may be up against CPS, that whatever other entities are there, and now you're like, but I can't afford an attorney to help protect myself and my child. I also can't afford an attorney for a superintendent's hearing. That doesn't automatic. That's not given to you like it may be in a criminal case if you can't afford it. So you're asking an unsophisticated or someone not knowledgeable in CPS hearings, family court, as well as in disciplinary hearings for the school, to say, you know what, I'm going to represent myself. Now, where is this all fair? And now you're affecting, because you don't have the money to properly equip yourself, a 15, a 14, a 17-year-old, a 12-year-old child. I mean, I just don't see it as fair.
Well, it can be very unfair, and again, the biggest problem is divide and conquer. If you have different people handling different fragments or different sections of the same incident, which gave to all sorts of different types of liability, then you're really at a loss to try to have an integrated approach to making them all go away.
And I appreciate your integrated approach, but I'll tell you where I have a problem, and correct me if I'm wrong, is that there's different burdens of proof.
Absolutely.
CPS has one burden of proof, the school hearing has a different burden of proof, and if it's a criminal case, the DA, the affirmative defenses. Can you go into that a little? Let's talk about burden of proof on a criminal case on a very general level, and then also what you've noticed with school, who has the burden of proof, and you do have to speak.
Well, it's all
See, now, how do we do that integrated approach? Now it becomes a little bit,
well, one of
jaded.
the I think
Cloudy.
the keys to it is by sitting down with counsel who with the family can determine what are the priorities here. So that is the first priority to avoid a criminal record, the second priority to make sure that the student graduates, the third priority to make sure that they go to their prom. And if there's more than one student involved, it becomes even more problematic, because in the same example I gave you, we had 3 honor students that were facing 3 different problems for each of them, which was whether or not they would graduate, which to me would be the top priority, whether or not they would be permitted to attend graduation, which minor, but the second priority, and the third priority was would they be permitted to go to the prom. And I will tell you that the 3 families did not agree on what the most important priority was, because you had one family who were arguing that they'd bought flowers and they'd rented a limo and they rented tuxes, and the girl had spent money on a dress, and that seemed to concern them more than whether or not the student would be permitted to graduate. For other families, they were more concerned about the graduation. A third family took the opinion that you're not going to graduation regardless after pulling a stunt like this and putting us through all of this. So when you have more than one student charged and having them handled as multiple or as co-defendants in a criminal matter, it becomes even more complicated.
But even more complicated than that, like in a criminal matter, obviously, you don't have to take the stand, you don't have to say anything. Mm-hmm. And it can't, theoretically, it's not used against you under the Constitution. However, in the CPS, you say nothing, that that doesn't hold water. And secondly, if the parents don't cooperate, that doesn't hold water. That could be used against you. Now, a statement that you have in a criminal case that may not be used, let's say it's Brady material, exculpatory in some manner, or there's some defect, can be used, though, in a CPS hearing that can't be used in a criminal.
Right, again,
And I've
because the
seen
burdens of proof that you referred to are different. Obviously, the highest level in a criminal case, which is proof beyond a reasonable doubt, and as you know, when we start to getting into the civil arena, now we're talking about clear and convincing or by a preponderance, and
And in
the
a
less
school board-
severe the consequences, obviously, the less the burden.
But I see, now it's interesting. I would seem to think, and a lot of people might not be thinking about this, let's say the child is deemed a minor. Let's say they're 16, 17. I might, assuming it's not a felony, I might say, you know what? You're better off taking a misdemeanor because once you hit as an adult, it's going to be sealed anyway. And you're not going to have
Well-
a criminal. Theoretically, you may be better off.
That can be an issue as well, because it doesn't get sealed automatically.
But I'm saying
when
you
you've
could
got-
maybe, it's easier for you to work as a criminal defense attorney to work in that arena.
Right.
Because let's just say, if it's a prank, if it's this, and nobody was really injured, and it just went awry, but no great consequences, a DA may say, look, it's the kid's first chance. You know, he never did anything before. Let's not ruin the kids. We have other bigger fishes to fry. Where a school may say, we need to make an example of this so that it doesn't happen in the future, so that our students and our student body realizes the seriousness of this. So, you know, that's one way I might look at it. What do you think?
I'm always more concerned with the aspects of a criminal case. You'll end up with DAs that will tell you that somebody can be adjudicated a youthful offender.
Right.
There'll be no criminal record, but you were a criminal practitioner yourself, and you know when we look at a criminal record, or if you have access to getting these records, even pursuant to a
Right.
court order, you know that if it was a youthful offender adjudication, it was really a criminal conviction that was set aside simply because of age, which is a lot different than getting a case dismissed or reduced to a violation which is not criminal to begin with. And in addition, if you're dealing with students, you have to think about where they're going to be 3, 4, 5, 10 years
Maybe
down
they
the
want to be a
line.
police officer. Maybe they want to work in a public
Anything that
office.
requires licensing, this will still become an issue potentially and require explanation. And if they end up in trouble again at a later date, then this is no longer the first instance.
So I think something that can be taken from your comment right now is it's important when you're hiring an attorney that they look at the big picture. They get to know you as a family, what your plans are as a child, what the parents' plans are, also quite possibly their immigration status. We talked a little off air about immigration status, which is a whole nother topic. This could affect their immigration status.
Absolutely.
They could actually be thrown out of the country. But, so choosing the right attorney that understands the consequences, not just the now, but for the future, all stems from listening. And you as an attorney over, we'll say 20 years,
You're too
you learn that, you know what? You better listen to the big picture. Everybody's interests are a little different, but at the same time, sometimes you as the attorney have to set the parents straight and say, wait, you're missing the boat. You got to think about your young son, your young daughter's issues down the road. You know, they want to go to college. They want to do this. Do you realize they have to be, if they want to be a broker, even if they want to be a cosmetologist, they have to be licensed by the state. And a state license is a privilege. It's not an absolute right, just like driving. So, I mean, do you agree with that?
Oh, absolutely. But again, I think it comes down to something that you just said, which is you have to find a professional who's going to listen. So that, for example, we have young people that are involved with their first DWI. When they find out they could lose their license, they're more concerned about losing their license than they are the criminal record. That's not necessarily the priority for the parent who is already taking the position, you're not driving until you're 21 to begin with.
No, till you're 40.
Or whatever it might
Some of
be,
them
you're
say.
no longer driving our cars. So again, listening and determining what the priorities of the client are, or the family in this case, because you've got a minor who can't make their own decisions, to me is going to be key as to how the case is going to be handled. The same way that when you're dealing with adults with a criminal case, one client's more worried about probation, another client's more worried about jail. Every client is different, everybody has different philosophies. And you have to find out what that philosophy is. And again, I think have an integrated approach as to not only these different facets of the same case, but you have to make sure the whole family is on board with the defense strategy.
But now, are there times when you want to speak to the child without the parents?
Always.
Because sometimes parents, you know, when they're in front of their father, their mother, their aunt, or whomever, they feel like I'm being ganged up on. If I say this, I'm already not going to be allowed out till I'm 26. Now they're going to make it till I'm whatever, or they're going to tell me to go live with my aunt and uncle in North Carolina who will beat me, you know, and they're much stricter. So do you find that you may have a conflict there sometimes when you just have to speak with the child, and then you're like, please don't talk to my father about it or my parents? You're kind of now monkey in the middle.
Happens all the time, and the best example is we had a young student years ago who was selling drugs in a local high school. Another honor student. Parents brought him in. Of course, as far as the parents knew, he was an honor student. He didn't use drugs. He didn't deal in drugs.
Because his grades are good. Why would he? This isn't my
Gave
son.
him no problem.
And the
he gave
parents
no
are in
problem.
denial a lot of
Because
times.
he wasn't using, he was selling, which is why he had a lot of discretionary income that didn't seem to concern the parents. We always interview the child independent of the parents, unless the child asks to have a parent present. The same way that when you go to see a doctor, you wait outside. We have to bring the student in, we bring the child in, we explain to the parents that if they retain us, the child is a client. That's where the attorney-client privilege attaches. The parents are paying the fee, and we try to involve them as much as possible. If that student or that child can't trust us implicitly to tell us everything that we're dealing with, then we can't represent them. And in that particular case, we had a situation where, as far as the parents were concerned, the child was an angel who would never give anybody any trouble, and this was nothing more than a fabrication by the police and the school authorities. As soon as this young man came into my office, he said, "Of course I'm selling drugs. Why do you think I'm wearing a fancy watch and these expensive sneakers and all these other accoutrements of success at the high school level? But you can't tell my parents. It'll kill them if they know." And it put us in the unenvious position of having to explain to the parents when we recommended a plea bargain instead of a trial, because as far as the parents were concerned, this case should go to trial because he'll be found innocent. I can't tell them what the child said to me to explain why I wouldn't.
But now let's go with that example. They say to you, you know, Alan, what do you think our chances are? And you say, in my professional opinion from doing this for years, I think it's probably in the best interest of your child. And they're saying, you know what, we'd rather pay for justice, this, and this. How do you eventually, you know, you got to talk to them and say, well, you can't say, I can't tell you everything I know, because now you're potentially violating, but your client's interests here and his confidence. But how do you equate that?
It took several meetings, but it finally got through to the client, who was the student and the child, that he had to explain to his parents what was going on, or he faced the likelihood that the truth was going to come out in a trial, which, even though it would not have been public because he was a mandatory youthful offender, meaning the courtroom would have been sealed, his parents would have found out. And this way we were able to get him to have a conversation with his parents, but we had to convince him to tell them, because it couldn't come from us, and then ameliorated the situation by immediately getting him into counseling and resolving the case. And the same way that you suggested before. I mean, we basically said, based upon all the information that we had after interviewing their son, our feeling was that he stood a greater likelihood of being convicted after trial than acquitted, but they'd really have to talk to their son to
That there
find
was
out
strong
why.
evidence.
Absolutely.
But now, theoretically, when this young kid goes in front for a plea, the parent is right beside them or right behind them, and the judge wants to make sure, is everything fully explained? Do you parents, when they allocute, or when they plead guilty, they talk to the parent as well? Mm-hmm. The parent could say, I disagree with it, I don't agree with the attorney, and I don't agree with my son. Now, in that situation, do you then ask to approach the bench in camera, meaning without anybody else, just you and the judge, without the DA, because there are certain things you may say to the judge, or would you say it in front of the DA at the bench? How do you handle that?
It would depend upon the individual situation, but I don't think we would ever let it get to the point that that was a colloquy that was taking place on the record. That would have been dealt with ahead of time. And truthfully, if we hit an impasse between the child and the parent, we might suggest that at that point, they should consider getting other counsel, because I can't divulge what the child said, but I can't put the child in a position where, as a lawyer, we end up trying a case we know we're going to lose because the kid doesn't want to tell his parents what really happened here.
Or the parents don't want to believe little Johnny or little Mary is not quite the angel.
Right. And fortunately, I have found over the 20-plus years that I've been practicing that it's never gotten to that impasse. Eventually, we penetrate this shield that the child's putting up and try to ameliorate the situation, have them get together and as a family realize there's an issue that has to be dealt with here, and a trial is not the way to do it, not with everything that's at risk and at stake.
So, and if it didn't work that way and they didn't see to what you believed was the right advice and they wouldn't get another counsel, you'd actually have to make a motion to get off the case for potentially, I guess, conflict or not being able to work well. You got to be careful even what you put in your affirmation there too.
Well, it becomes very difficult to effectively represent the client when the parents who make the decisions for the child are making decisions that are adverse to his best interest. So I think clearly there's a conflict at that point. We've been able to resolve it. If you can't, that would be an awful situation.
So you've had many of those frustrating meetings with parents.
Our share of them.
Now, Alan, I know we went over a lot of different areas, different ways, and different burdens of proof, different courts. Obviously, there's not one right answer. It's really going to depend on the situation, and that's why you retain an attorney. What advice would you give from the way we started? Soon as your son or daughter calls and says, "Dad, Mom, what do I do? The police here, they want to talk to me." What's your advice?
The advice is call a lawyer and call somebody as quickly as possible that you can get immediately. These are not things that can wait. We get these calls all the time. We had one just last weekend from a client who was on the side of the LIE with a police officer who said, "I'll give you an opportunity to call your lawyer." It's always good to have a number available. It's good to have people available who can give you a number.
But if you don't know a lawyer, which a lot of people don't, when they're in time of need, an emergency, just like when you get arrested by a police officer on the road, the turret lights are going, you can't always think clear. Mm-hmm. So I think, personally, and I think you'd agree, that if you don't know what to do, say, you know what, at this point, I'd like to speak to my parents and possibly get a lawyer. Can we come back and get back to you, or am I arrested and I'm not free to leave?
Absolutely, because less is more. And you want to be polite and you want to be respectful and give your name and what you and I would refer to as pedigree information, but nothing about the incident. Not till you have an opportunity to speak to somebody else.
And you know what? It's funny, a lot of people say to me, well, they use this term. You know what? If I ask for a lawyer, they think I'm lawyering up. They use the word lawyering up because they think then I must be guilty, so I better talk. And I hate when I hear that, because I always say, you know what, as you sit here today, you're presumed innocent. And you don't have to say anything.
Well, that's because, unfortunately, people in general and people who are not normally in trouble with the police seem to feel that there's some cathartic effect to confessing and to telling what they've done and to think everything will be fine. It doesn't always turn out that way.
Well, I want to thank you for coming on Legal Straight Talk. Thank you
My
again,
pleasure.
Alan.
Thank you for inviting me.
Hi, I'm Jerry Parisi. Join Tom Mealy and Tommy Marr right here on Cablevision Channel 20 each week for an interesting episode of The Long Island View.